35 number 3
Start again. Yes.
Page wise adjournment from admission matter, page 14, 67 to 69. Page 15, 72, 74.
My lord, 70, my lord. I am for the appellant, my lord.
Yes, Mr.
I request short accommodation, my lord. Serial number 70, my lord. MAP
Yes, yes.
5001 2019.
Request of our counsel for the appellant. Released after a week.
Much obliged, my lord.
74 minutes.
Which matter?
71.
71. Request of our counsel for appellant. Release this matter after a week.
74 minutes.
Yes.
Could it be taken up after 10 days?
Yes. Havaldar. In injury matter.
Injury matter. In fact, I
Connected.
wanted it to be remanded. Yesterday I had it talk.
All right. You take notice in the other matter, Mr. Swami.
Yes. I take notice.
Really? Progress one stage at least. ಅದು ಬಂದು ಕಾಪಿ ಕೊಟ್ಟಿದ್ದಾರೆ ನಿಮ್ಗೆ ಅದರಲ್ಲಿ?
ಕೊಟ್ಟಿದ್ದಾರೆ.
Which respondent are you?
And in fact, I am respondent number 2 in that case. Insurance company.
All right. Then counsel 74 ಅಲ್ಲಿ. And then counsel 3. A.N. Swami accepts notice for the respondent number 3.
2 minutes. Insurance company.
In MFA 2673 for the insurer. Release this matter after 2 weeks.
Much obliged.
At his request.
Page 16, 75 and 76.
Put it. KSRTC. Challenging liability. Heard counsel for the appellant insurer. Issue notice to respondents. Orders on IA1. There shall be stay of execution of judgment and award passed in MVC 797 of 2021, dated 14/12/2021, passed by MACT and First Additional Small Causes Judge Bengaluru SCCH 11, subject to the condition that the appellant deposits 50% of the award amount. For this quota, before the MACT, Huh? Said amount shall be deposited within a period of 6 weeks from today. Liability. So you are shifting it to the owner. Your case is to shift it to the owner. But for heard learned counsel for the apparent insurer, issue notice to the respondents. Orders on IA1, there shall be stay of operation of judgment and award passed by third additional judge and MACT, Court of Small Causes Bengaluru, SCCH 18 in MVC 231. Subject to the condition that the appellant deposits 50% of the award amount before this court, in a period of 4 weeks. 2 lakhs and odd they have given. Vijay Kumar,
D.
mute ಮಾಡಿದ್ದೀನಿ.
This appeal is by the Reliance General Insurance Company challenging negligence and quantum of compensation. I am ready to deposit 50% of the award amount before High Court within 4 weeks.
Heard learned counsel for the appellant insurer. Issue notice to respondents. Orders on IA2. There shall be stay of operation of judgment and award dated 18/11/2021 in MVC 2860 of 19.
In serial number 4, it gives the respondent.
CCH 13. Subject to the condition that the appellant deposits 50% of the award amount for electricity.
Before High Court, my lord.
Are you challenging liability?
Yes, my lord. Yes, my lord.
Before this court within a period of 4 weeks. Third, counsel for the appellant KSRTC. Issue notice to respondent. Orders on IA1. Third, there shall be stay of operation of judgment and award passed by the MACT and Small Causes Judge Bengaluru in MVC 81 of 2019, dated 25/10/2021, subject to the condition that the appellant deposits 3% of the award amount. What are you challenging? MACT ಮಾಡ್ತೀರಾ? Before the MACT. K.N. Srinivas. K.N. Srinivas. Next part. There is no representation previous next week. Jay Kumar.
My lord, appeal by the DMTC, my lord, challenging negligence and quantum of compensation. My lord, tribunal has awarded, my lord, 24,18,000 rupees. I am ready to deposit 50% of the award amount The respondent may be permitted to withdraw subject to result of the appeal.
You're challenging liability?
No liability, only negligence and quantum of compensation. Appeal by the BMTC.
All right. Recording. Heard learned counsel for the BMTC Corporation. Issue notice to respondents. Orders on IA 1 of 2022. There shall be stay of judgment and award dated 27/11/21 in MVC 42 of 20 in the file of MACT and fifth additional judge small causes SCCH-20 Bengaluru, subject to the condition that the appellant deposits 50% of the award amount before the MACT.
My lord, High Court, my lord, so that they will appear and matter can be disposed of.
All right, before the High Court, before this court, within a period of 4 weeks from today. Sitappa, heard issue notice to respondents. Yes. 8 to 11. Only quantum.
My lord, serial number 8, my lord.
Issue notice.
Yes, much of.
Heard. Learned counsel for the appellant. Issue notice to respondents. Orders on E1. There shall be stay of operation of judgment and award. Dated 7 December
With your
21.
lordship kindly, my lord, serial number 3, my lord.
7 December 21. The Court of Additional Senior Civil Judge and MACT Pandavpura in MVC 1425 of 2020. Subject to the condition that the appellant deposits 50% of the award amount for the MACT within a period of 4 weeks from today.
Serial number 14, my lord.
Yes, 13. There is a note below.
All this. Oriental Insurance Company, branch office, first floor, city. The award not be page number 70. Page number 70.
Oriental Insurance Company, branch office, TGMC building. Early judgment early.
Page 12. Address not only differ, the company is same. They accept the once is repeated. Request to overrule this officers. Okay, but the policy and even the.
So, name trial court petition early. Award and difference. Not your mistake. You have to say it vociferously. That's not my mistake, and I should not be held responsible for the fault committed by the court. ವಿನಾಯಕ ಕಾಂಪ್ಲೆಕ್ಸ್ ಮಾಡಿದ್ದಾರೆ. Third learned counsel for the appellant on the objections raised by the registry. The objection is with regard to the address of the respondent number 2, which differs from the judgment to the award. Learned counsel submits that this is not at the instance of the appellant. It is the mistake or an error committed by the court. Therefore, he cannot be held responsible for the same. Sustaining the said submission, the objections raised by the office is overruled. Third learned counsel for the appellant. Issue notice to the respondents. Orders on IA 1. There shall be stay of operation of judgment and award dated 9/12/21 MVC 1137 of 2017. Passed by senior civil judge and additional MACT at Sira, subject to the condition that the appellant deposits 50% of the award amount before the MACT within 4 weeks from today.
My lord, I am for the appellant, my lord. My lord, I've already furnished the process on 9/8/2021. I don't know what has happened to that notice. If I know what is this thing, then my lord, I can take further steps. In the meantime, my lord, I have sought for stay, my lord.
Addressee not claimed. Addressee not claimed ಅಂತ ಬಂದಿದೆ.
Not claimed, then it is service held sufficient. If he refuses to receive the
This is through court or the post?
through court only.
ನೀವು ಥ್ರೂ ಕೋರ್ಟ್ ಅಂತೀರಾ, ನಮ್ ಕೋರ್ಟ್ ಆಫೀಸರ್ ಪೋಸ್ಟಲ್ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಅಂತಾರೆ.
ಅಲ್ಲ, ಪೋಸ್ಟಲ್ ಥ್ರೂ ಕೋರ್ಟ್ ಪೋಸ್ಟಲ್ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಹೋಗ್ಬೇಕು.
There is a shara. Postal, where is the postal shara? See, not claimed. Not claimed is to be taken as served.
Deemed to have been served.
Where is that circular yesterday you gave me? The notice issued to respondent Obrena
But only respondent.
issued to respondent is returned as in addressee not claimed. Addressee not claimed. Therefore, the same would amount to deemed service. Therefore, registry is directed to show the name of respondent, namely G.K. Manohar, in the cost list. Full stop. Any other appeal?
My lord, appeal by the BMTC, my lord, challenging negligence and quantum of compensation. Rupees 8,54,017 is awarded. We have disputed the negligence and quantum of compensation. I am ready to deposit 50% before this honorable court. Stay may be granted.
Third learned counsel for the BMTC Corporation. Issue note the orders on IE 2 of.
And my lord, one more submission, my lord.
Mistake. Judgment and award 11/7 passed in MBC number 257 of 14. 10. Roman 10. Tumkuru, subject to the condition that the appellant deposits 50% of the award amount before this court.
One more submission.
Weeks.
One more submission, my lord. One more submission. The respondent has already filed execution number 399/2018 If any amount is deposited in the execution court, my lord, that may be treated as the condition to the stay order.
No,
Your
you are
last-
now directed to deposit 50% of the amount for this court.
Yes, my lord. In
What
case,
else you want?
my lord, the respondent have already filed a EP number 399 by 2018. In that, my lord, if the BMTC has deposited any amount, my lord, again it will amount to duplication of depositor. Therefore, that amount may be treated, if
What is-
any. That if any amount is
What is the
deposited,
amount?
my lord, award, my lord, 8,54,000
No, no. Have you
awarded.
deposited? Have you
What is it?
deposited in the execution court?
We might have deposited some amount.
You find out, no? Might may andra henge. Come out clearly that you have deposited. We'll include this also. in the
Yes, ma'am.
Order of
And-
50% deposit. Yes,
Stay
anything
may be
else?
granted, my lord, that I'll verify, my lord.
Granted.
Much obliged, my lord. Much obliged.
Yes, Rayaka. Weeks time granted to do the needful. In the fourth time, howda? Needful done, issue notice to respondent number 1.
I am appearing for the
Compliance.
appellant, my lord. Week's time may be granted, my lord, to do the needful. my
Weeks
lord.
time granted to do needful.
Much obliged.
Hanumantappa. First time, huh? Weeks time granted. If needful done, issue notice to R1 to 4. Weeks time granted to do the needful. We'll release the amount. Kulam, 50%. You're on quantum. So entire 50%. This application, third learned counsel for the appellant and respondent, and learned counsel for respondent. This application is preferred by the learned counsel for the respondent, seeking to withdraw the amount in deposit made by the corporation, insurer, made by the insurer, which is deposited before the MACT. The challenge in this appeal is with regard to the quantum, with regard to excessive quantum being awarded in favor of the claimant. Therefore, the application IA number memo is allowed. Claimant is entitled for withdrawal of deposit amount of 50% made by the insurer, appellant insurer, for the tribunal. Full stop. Tribunal is directed to release the entire 50% in favor of the respondent claimant. Respondent claimants, subject to proper verification. Are you giving bank details? Bank details ಕೊಡ್ತೀರಾ ಅಲ್ಲೇ ಹೋಗಿ ರಿಸೀವ್ ಮಾಡ್ತೀರಾ? On proper verification. Stop. Registry to return the LCR for the purpose of the compliance of above order and the trial court to return the same forthwith. Fifth matter, Srinivas. ಯಾರು ಬಂದಿಲ್ಲ ಅಂತ ಅಟೆಂಡ್ ಮಾಡಿ. All right, you are for insurer. Liability. You are now shifting it to the owner. Third learned counsel for the appellant insurer. Issue notice to respondents. ಏನು ನೀವು ಹಿಂಗಾಗ್ತಿರಲ್ಲ ಎಲ್ಲ ಬ್ಲಾಕ್ ಮಾಡ್ಕೊಂಡು ಇಲ್ರಿ ಅದ್ರ ಕಂಪ್ಯೂಟರ್ ನೀವ್ ಮಾಡ್ತೀರಾ ನಿಮ್ ಕ್ಲರ್ಕ್ ಮಾಡ್ತಾರ ಅವ್ರಿಗೆ ಹೇಳ್ಬೇಕು. This is either blocking or cut and paste. No dictation, sir. It is not dictation. It's a mistake of the computer on a software which you have not corrected it. Block here with block or bolded. Orders on IA 1. There shall be stay of operation of judgment and award in MVC 93 of 2017 dated 3/9/21, passed by the second additional senior civil judge and MACT Kolar, subject to the condition that the appellant deposits 50% of the award amount. Yell Martira before this court within a period of 4 weeks. That's Roman. 20. 4 weeks time granted to do needful at request. The
8833.
is in connected matter 8833, 4 weeks time again same 4 weeks time granted to need to take necessary steps. Two weeks time granted if needful done, issue notice to R1 and 2. of MFA 56 of 2020 along with this appeal.
My lord, in this case, my lord, respondent reliance is served, I'll take notice.
Learned Counsel Sri Vijay Kumar, B. Vijay Kumar accepts notice on behalf of respondent number 2, registry to show its name. Learned Counsel for the appellant to furnish a set of copy along with the order to the Learned Counsel for R2. Huh? ಹೇಳಿ ನಂಬರ್ ಹೇಳಿ ಇದ್ರಲ್ಲಿ ಇದೆಯಾ ವಿಜಯ್ ಕುಮಾರ್ have you filed appeal?
That I'll verify, my lord. Let them furnish the case.
ಇದ್ದೀರಾ ಹೇಳಿ ನಿಮಗೂ ಅವ್ರಿಗೂ ಗೊತ್ತಿಲ್ಲ ನಿಮಗೂ ಗೊತ್ತಿಲ್ಲ ಇವ್ರಿಗೂ ಗೊತ್ತಿಲ್ಲ ಏನ್
I'll verify, my lord.
find out sir. Find out. If it is there we'll connect.
61 but just a minute, man. We'll verify, my lord.
Needful is done with weeks time. What is that? Yeah, it's stated that needful is done. Registry to verify issue notice to R1.
Delay may be condoned in that. Delay may be condoned.
ಮಾಡ್ಬೋದಾ
ಮಾಡಿ
ಲಯಬಿಲಿಟಿ ಯಾರ ಮೇಲೆ ಇದೆ ಇನ್ಶೂರೆನ್ಸ್ ಮೇಲೆ ಇದೆಯಾ ಆಲ್ ರೈಟ್ yes orders on IA1 heard IA1 allowed 62 days in filing appeal condoned. Next.
My lord, I seek for 2 weeks accommodation. My lord. In view of amalgamation, I am unable to get the details.
All right. What about we'll condone delay? Sashidhara.
6696 for MFL.
Sashidhara. Condone delay. Nimage, you want a week's time to deposit?
2 weeks time to ascertain the date of deposit. Amalgamation.
Heard learned counsel for appellant and the learned counsel for respondent 5. Orders on IE1. IE1 allowed 77 days delay condoned. ನೀವು ಅಸರ್ಟೈನ್ ಮಾಡ್ಕೊಳ್ಳಿ ಎಕ್ಸಿಕ್ಯೂಷನ್ ಹಾಕಿದ್ರೆ ಅವರು they will proceed ಅಷ್ಟೇ
ಆಗ್ಬೋದು.
My lord, in the previous matter, my lord, the insurance company has filed MFA 6696 of 2019 through Ashok and Patil.
6696
of 2019.
6696 of 19. Registry to list MFA 6696 of 2019. So now in view of that, you want to appear or will tell
Ashok? No, my lord, Ashok and Patil is going to appear.
Ashok and instead of D. Vijay Kumar, Ashok and Patil. Understood? Yes, Mr. Patil, you are being directed to take notice. 25, Nagaraj.
function.
Rajendran. No liability on 1 and 2. Is insurer. All right. Worked.
So, on the date
Notice to respondents number 1 and 2 dispense with as there is no liability passed in. Full stop.
13-4.
Orders on IA.
Sorry.
1 of 22. IA 1 is allowed delay of 127 days. Control. Yes. Next. Satish.
Appear for appellant, my lord. Aspect number 3 is the driver of the vehicles, not necessary, kindly dispensed with, my
R3 is a driver.
lord. Driver, my lord.
All right. Worked. ನಿಮ್ದು appeal ಇದೆಯಾ? ಅದರಲ್ಲಿ notice ಯಾರಿಗೆ?
R6
Notice
driver, my lord.
R6 is the driver.
So we can dispense.
It's fine.
Yeah.
It is issued a trade policy. The vehicle was sold not and the policy was again issued by the LIC insurance company. It's not for the trade or not. Policy will be
No, even if the policy is issued to, how will the driver be liable? All right. It is submitted by learned counsel for the appellant that respondent number 3 is none other than the driver of the offending vehicle and there is no liability fastened on him. Hence he seeks dispensation. ಕೊಟ್ಟಿದ್ದೀರಾ memo?
Tomorrow file ಮಾಡ್ತೀವಿ sir. File it in office.
Seeks dispensation on the application being filed. Notice to respondent number 3 is dispensed. In the connected appeal, learned counsel for the appellant insurer seeks 2 weeks time. 2 weeks time. 2 weeks time to ascertain certain details. Same is granted. Relist after 2 weeks. On. R2. ಯಾರು R2? Liability ಯಾರ ಮೇಲೆ ಇದೆ? ಅವ್ರ ಮೇಲೆ ಇದೆ. Okay. 2 weeks time granted. If needful is done. Issue notice to respondent number 2.
28 climate appeal. I represent as appellant, my lord. Reliance Insurance Company may be directed Vijay Kumar, my lord. Reliance Insurance Company also filed appeal, my lord.
Reliance ಡಿ ವಿಜಯ್ ಕುಮಾರ್ ತಗೊಳ್ತೀರಾ?
ಅವರು ಫೈಲ್ ಮಾಡಿದ್ದಾರೆ, ಇನ್ನೊಂದು ಅಪೀಲ್ ಅವರೇ ಫೈಲ್ ಮಾಡಿದ್ದಾರೆ.
ಅವರೇ ಮಾಡಿದ್ದಾರೆ. ನಂಬರ್ ಹೇಳಿ.
8999 my lord. 8999 8
of
19 my lord.
Registry to list MFA 8999 of 2019. Preferred by the insurance company against the very same impugned order. Full stop. Learned counsel Sri D. Vijay Kumar is directed to D. Vijay Kumar.
Vijay
Kumar.
mute ಮಾಡ್ಕೊಳ್ಳಿ. ವಿಜಯ್ ಕುಮಾರ್ ಅನ್ಮ್ಯೂಟ್ ಮಾಡ್ಕೊಳ್ಳಿ.
Unmute ಮಾಡ್ರಿ.
Please, madam.
In this 28, you accept notice, you have filed appeal.
Yes, my lord. Yes, my lord. MFA 8999 of 2018.
ಬರ್ದೈತದು.
Please.
Learned counsel Vijay Kumar accepts notice on behalf of R3 registry to show his name. So liability ಯಾರ ಮೇಲೆ ಇದೆ?
ಇನ್ಶೂರೆನ್ಸ್ ಮೇಲೆ ಇದೆ my lord. ಅವರು ಚಾಲೆಂಜ್ ಮಾಡಿರೋದ್ರಿಂದ ನೋಟಿಸ್ ಹೋಗ್ಬೇಕಾಗತ್ತೆ ಅನ್ಸುತ್ತೆ.
All right. So you can't dispense then 2 and 4.
Yes, my lord. ಅವರು ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದಾರೆ ಏನು? Permit me to take out notice, my lord.
You take out PF paid within a week's time. Registry to issue notice to respondents 2 and 4. Orders on IA1. A1 allowed 96 days delay condoned.
Please, my lord, oblige.
My lord, I am for the respondent, my lord. I am ready for argument.
Ready?
Yes, my lord.
All right. In death case, No liability
My
on
lord, it is a
R1.
very, my lord, it is very simple, my lord. There is no dispute with regard to the liability and also negligence. My lord,
All right, you wait for your turn. We'll complete the list and come back.
much obliged. That is better. That is better.
Sharif, Mohammed Sharif.
I appeal for
PFA.
first respondent, my lord.
Ah,
First respondent. Delay may be
PFA
condoned,
in
sir.
a week's time, issue notice to respondent number 2. Kulkarni.
My lord, I appear for applying now. R1, my lord, is the, I have filed memo for dispensation to R1, my lord.
Ah.
Delay may be condoned, my lord.
No liability.
No, liability is on the insurance company.
All right,
They have admitted the liability.
Notice to respondent number 1 is dispensed as there is no liability past time. Stop. Orders on IA1 heard counsel for appellant and heard counsel for respondent. IA1 allowed. Delay of 55 days condoned.
My lord, the matter may be listed for admission.
List this matter for admission.
Date. ಇಲ್ಲಾಂದ್ರೆ ಲಿಸ್ಟೇ ಆಗೋದೇ ಇಲ್ಲ.
ಬರುತ್ತೆ ಯಾಕೆ ವೈ ಲಿಸ್ಟ್ ಆಗಲ್ಲ ಮ್ಯಾಟರ್ಸೇ ಇಲ್ಲ. We are disposing of matters, madam. There are no matters for final hearing, no matters, only orders ಅಲ್ಲೇ ಒಂದು 1,000 1,500 ಇದೆ.
Difficulty is we have to file application again to list this.
For what? For listing?
For listing, my lord. Yes, my lord.
What is the matter?
2019.
But when is the date of accident?
My lord, 2018, my lord, date of accident.
It will come up, madam. List this matter for admission.
Please, my lord. Obliged.
Prasanna. Number. Use the mic. I can't hear you. You're trying to come closer to me. It makes no difference. It makes no sense. You have to stand near the mic and MFA 2304 of 19. Registry to lift MFA 2304 of 19, which is preferred by the insurance company, agreed by the very same impugned judgment. Yaro idu National Insurance Company. Ramkrishna has filed. Okay, then let that matter come up in our order. Then IA1 for dispensation not pressed. IA1 of 2020 is dismissed as not pressed. IA1 is dispensation not pressed because you have said so. Let it come up, we'll dispense even production. Mr. Sitaram Rao.
I'll take steps in respect of respondent number 2, Milad.
Week's time granted if needful done, issue notice to R2. Yes, Mr. Krishna.
I will be doing the needful within a week, my lord.
If needful done within a week's time, issue notice to respondent number R2. So, respondent number 2. Yes. Only respondent, huh? For calling. Heard learned counsel for the appellant corporation, huh? KSRTC. KSRTC. Respondent is served but not represented. Order 2. IA2 allowed delay of 143 days in filing the appeal is condoned. Deposit madilena. IA1 for dispensing production of certified copy. Why production of certified copy? Now, whether in that, so 11 cases, any other respondent is there? No, different respondents. But then again, in this case, since the respondent is served, certified copy would be required because we are not connecting it. Are you trying to connect the matters? Okay. All right. Of no, you get those matters connected, then we will dispense. Connect really agide. Ilri, call. What are those list of cases you give? We'll call everything together. ಅದು ಕೊಡಿ. ಇವಾಗಲೇ ಕೊಡ್ತೀರಾ? ಕೊಟ್ಟಿದ್ದೀರಾ? Leonard, ಬರ್ಕೊಳ್ಳಿ. Leonard Council submits that he has given the list of appeals preferred by the claimants. Huh? All right, release next week. Next, Krishna Swami.
My lord, this is connected with serial number 34, my lord. Same order. A week's time may be granted.
Week's time granted to do needful. If needful done, issue notice to respondent number 1.
Much obliged.
Yara idhar alri R1, R2. Sorry, R2. R1 is available. Keshav Prasant.
For the appellant in this case.
Yes, Mr. Keshav Prasant.
Week's time may be granted to ascertain whether it was deposited or not.
All right. What about delay? Opanna? Rangegowda. Heard. Orders on IA1 of 19. IA1 allowed delay up to 08 days condoned. However, an appellant being insurance appeal.
Also, insurance appeal.
IA1 allowed delay condoned.
In this case, there is one submission, my lord. R2 is the owner of the vehicle. Liabilities on the owner. By oversight, I have filed the memo for dispensation of notice to R2. R2 is a necessary. Notice to R1 and 2 kindly be ordered.
Week's time granted to do needful done. Registry to issue notice to our respondent 1 and 2.
Much obliged.
Nagaraj. Banu Prakash, you are appearing for R2. There are KSRTC. Then who's 3? Who's 3? Who is 3, sir? The counsel for the appellant submits that R2 is the insurance company KSRTC, is represented by Leonard Counsel VG Banu Prakash. Further submitted, respondent number 3 is none other than the internal insurance of respondent number 2. That counsel seeks a week's time to verify the same and make a representation on behalf of R3. Yaru? No liability. All right. Notice to respondent number 1 is dispensed as no liability is fastened. Orders on IA1. IA1 is allowed delay of 96 days is condoned. Copy kottidira avarge. Manjunath. Week's time granted to do the needful. Shastri G. Shastri G. Allah, Bari Shastri. Shripad Shastri. Shripad V. Shastri.
Yes, I am for appellant, my lord. I am for appellant. My lord, actually, R1 only I required to issue notice to R1 only, because there is no dispute regarding quantum. So I dispensation seek for insurance company and R3, owner of the vehicle. There is only the apportionment of compensation. My lord, there is first time.
Take out notice.
ಅಲ್ಲ ನಾನು 35 rupees ಇದನ್ನ ರಿಟರ್ನ್ ಮಾಡಿದ್ದಾರೆ, ಯಾಕೆ ಹೇಳಿ ಗೊತ್ತಾಗ್ತಾ ಇಲ್ಲ. R1 ಗೆ ಅಷ್ಟೇ ನೋಟಿಸ್ ಬೇಕಾಗಿರೋದು.
Set of IA copies ಕೊಡಬೇಕು.
ಆಯ್ತು, ಕೊಡ್ತೇನೆ.
If needful done within a week's time, issue notice to R2 and 3. Next, Manjunatha. Week's time memo for withdrawal of appeal.
ಅಲ್ಲ ನಂದ್ರಲ್ಲಿ ಸ್ವಾಮಿ ಸಾರಿ ಅದರಲ್ಲಿ R2 and R3 ಗೆ ಡಿಸ್ಪೆನ್ಸೇಷನ್ ಮೆಮೊ ಹಾಕಿದ್ದೇನೆ. ಇಟ್ ಶುಡ್ ಬಿ ಅಲೋ.
ನಿಮ್ದ್ರಲ್ಲಿ ಫಸ್ಟ್ ಟೈಮ್ ಅದು ಹೋಗ್ಬೇಕಲ್ಲ ನೋಟಿಸ್ ಫಸ್ಟ್ ಟೈಮ್.
ಅಲ್ಲ ಫಸ್ಟ್ ಟೈಮ್ ನಾನು ಡಿಸ್ಪೆನ್ಸೇಷನ್ ಕೇಳ್ಬಿಟ್ಟಿದ್ದೇನೆ ಫಸ್ಟ್ ಗೆ.
ಫಸ್ಟ್ ಟೈಮ್ ಓನ್ಲಿ ಯು ಹ್ಯಾವ್ ಟು ಗಿವ್ ನೋಟಿಸ್ ಅಂಡ್ ದೆನ್ ಓನ್ಲಿ ಯು ವಿಲ್ ಡಿಸ್ಪೆನ್ಸ್. ಲೆಟ್ ದ ಅದರ್ ಸೈಡ್ ಕಮ್.
ಅಲ್ಲ ಅದರ್ ಸೈಡ್ ಅಲ್ಲಿ ಅಪೋರ್ಷನ್ಮೆಂಟ್ ಅಷ್ಟೇ ಡಿಸ್ಪ್ಯೂಟ್ ಬಿಟ್ವೀನ್ ದಿ ಟೂ ಪಾರ್ಟೀಸ್. ಅದನ್ನ R1 ಗಷ್ಟೇ ನನ್ನ ಕ್ಲೇಮ್. ಡಿಸ್ಪ್ಯೂಟ್ ಇಸ್ ವಿತ್ ರೆಸ್ಪೆಕ್ಟ್ ಟು R1 ಅಂಡ್ ಕ್ಲೇಮೆಂಟ್. R2 and R3 ಡಿಸ್ಪೆನ್ಸೇಷನ್ ಕೇಳಿದ್ದೇನೆ. ನೋಟಿಸ್ ಮೇ ಕೈಂಡ್ಲಿ ಬಿ ಡಿಸ್ಪೆನ್ಸ್.
R1 ಯಾರು?
R1 is the wife of the deceased. It is a parent's claim that apportionment is to be rectified. ನಮಗೆ ಬರೇ ಅಷ್ಟಕ್ಕೆ ಡಿಸ್ಪ್ಯೂಟ್ ಹೊರತು ಕ್ವಾಂಟಮ್ ಮೇಲೆ ಲಯಬಿಲಿಟಿ ಮೇಲೆ ಡಿಸ್ಪ್ಯೂಟೇ ಇಲ್ಲ.
ಅಪೋರ್ಷನ್ಮೆಂಟ್ ರೆಕ್ಟಿಫೈ ಮಾಡಿದ್ರೆ would it not affect the other respondent?
ಇಲ್ಲ ಆಗೋದಿಲ್ಲ ಯಾಕಂದ್ರೆ ಕ್ವಾಂಟಮ್ ವಿಲ್ ಬಿ ಸೇಮ್. ಈಗ 100 ರೂಪಾಯಿ ಕೊಟ್ಟಿದ್ದಾರೆ, ಅದ್ರಲ್ಲಿ ನನಗೆ ಕೊಟ್ಟಿದ್ದು ಕೇವಲ 10 ರೂಪಾಯಿ ತಂದೆ ತಾಯಿಗೆ. 90 ರೂಪೀಸ್ ಹೆಂಡತಿ ಕೊಟ್ಬಿಟ್ಟಿದ್ದಾರೆ. ನನಗೆ ಜಾಸ್ತಿ ಕೊಡಿ, ಅಪೋರ್ಷನ್ಮೆಂಟ್ ಜಾಸ್ತಿ ಮಾಡಿ. ಕ್ವಾಂಟಮ್ ಅಷ್ಟೇ, ಕ್ವಾಂಟಮ್ ಕೊಟ್ಟಿದ್ದು ಕಡಿಮೆ.
Mr. Counsel,
my lord.
When there is going to be a change made by this court, would it not affect the apportionment to R2 and R3?
ಇಲ್ಲ R2 is the insurance company. They are already satisfied the award. I have no grievance against R2 insurance company. R3 is the owner of the vehicle. He is not liable. R2 satisfied the award. So
who are you?
I am parents of the deceased. Parent. ಅದಕ್ಕಾಗಿ ಪೇರೆಂಟ್ ಮತ್ತು ಸೊಸೆ ಅದು ಸತ್ತವನ.
All the claimants are the appellants.
Yes.
ಬರ್ಕೊಳ್ಳಿ. Notice to respondents number 2 and 3 is dispensed with, as the challenge to the appeal is only with regard to apportionment as regards the petitioner appellants petitioners. So ನಿಮ್ರಲ್ಲೇ ನಿಮ್ಗೆ ಅಪೋರ್ಷನ್ಮೆಂಟ್ ಚೇಂಜ್ ಮಾಡ್ಬೇಕು.
ಹೆಂಡತಿಗೆ ಜಾಸ್ತಿ ಕೊಟ್ಟಿದ್ದಾರೆ ಅಷ್ಟೇ ಗ್ರೀವಾನ್ಸ್. ವೆದರ್ ಇಟ್ ಇಸ್ ಟ್ರೂ ಆರ್ ನಾಟ್
ಕೊಡಬಾರ್ದು ಅಂತ ಜಾಸ್ತಿ
ಅಲ್ಲ, ಜಾಸ್ತಿ 90% 90 ರೂಪಾಯಿ ಕೊಟ್ಬಿಟ್ಟಿದ್ದಾರೆ. ಪೇರೆಂಟ್ಸ್ ದೂರ ಅಷ್ಟೇ ನಮ್ದು. ಸೊ
ಬರ್ಕೊಳ್ಳಿ. 42 serial number 42. A memo is filed by the learned counsel appearing for the appellant, which reads as under extract the memo. In view of the above, this appeal is dismissed as withdrawn.
ಅಲ್ಲ ಅಗೇನ್ಸ್ಟ್ R2 and 3 ಡಿಸ್ಪೆನ್ಸ್. R1 ಗೆ ಹೋಗ್ಬೇಕಾಗ್ತದೆ.
ನಿಮ್ದು ಆಯ್ತು. ನೆಕ್ಸ್ಟ್ ಕೇಸ್ ಆರ್ಡರ್ ಮಾಡ್ತಾ ಇರೋದು
ತಪ್ಪಾಯ್ತು.
What about 43? Shastri.
Sorry, sir. I will do the needful within 2 days.
If needful done within a week's time, issue notice to respondent 2. Respondent 3 and 4. R1, 3 and 4. ಇಲ್ಲ ಬರ್ತಾನೆ Manjunath is not well or what? 2 weeks time to do the needful in both matters. Sanath. Two weeks time granted. If needful done, issue notice to respondents 2 and 3. Suhani Olla. Two weeks time granted. If needful done, issue notice to respondents 1 to 5. The counsel submits that she has deposited 50% of the award amount as ordered by this court before the tribunal. Rish Kumar, if PF, if needful is done, issue notice to R1 and 2. PF paid within a week. Same order, week's time granted to do the needful.
I appear for appellant. I
Notice to R2.
I paid PF.
Paid,
on 28 to 2000.
Then
21
council
itself.
submits that he has already paid the process fee if needful is in order.
28/9/2021, I filed two.
Notice to R2. Yes, sir. If PF is in order, issue notice to R2.
I've already filed. How office has raised that objection, I don't know.
ಏನಮ್ಮ ನೋಡಿ ಅದು furnishing of PF correct acknowledgement.
I filed a dispensation memo in respect of R1.
ಯಾವಾಗ
And I
ಕೊಟ್ಟಿದ್ದೀರಾ?
paid PF in respect of R2.
ಯಾವಾಗ ಕೊಟ್ರಿ 20?
28/9/2021 itself.
28/9.
And I also filed memo to that of dispensation on 28/9/2021.
What is the order? Illa, it is showing that you have not paid. Just verify.
That's what I've got acknowledgement when I filed PF.
ಇದೆಯಾ ನಿಮ್ಮ ಹತ್ರ acknowledgement ಇದೆಯಾ?
ಹೌದು. I've got acknowledgement. On the same day, I filed another memo for dispensation and I paid PF to
All right. Learned counsel submits that he has paid the PF on 28/9/2021 itself, and he has got the acknowledgement to that effect. Registry to verify and issue notice to respondent number 2. Next. Await TCR. Await notice of R1. Shantaraj 53.
Yes, madam. Await TCR ಅಂತಿದೆ.
ಬೇಕಾಗುತ್ತಾ?
ಆ injury case.
All right. Await TCR. Shivanna Gowda.
My lord, I am appearing for the Mr. Shivanna Gowda, my proxy counsel. I have sent the deposit memo to the honorable court today, my lord. And
what about PF?
ಅದು ಈ ಒಂದು ವಾರ ಟೈಮ್ ಕೊಟ್ರೆ ಮಾಡ್ತೀನಿ ಸ್ವಾಮಿ.
Time granted. If
Please.
needful done, issue notice to R1 to 3.
Please.
Pradeep. Await. Appearing for respondent 1. Neva. What's your name? So you are appearing for R1, 2 and 3. Wakala takila ನೀವು. Registry to list MFA 288 of 2022 along with this appeal. Await service of notice. Week's time grant.
By one submission, I am for the appellant. Due to oversight, the affidavit is not solved. I am do it within a week. In the meantime, stay may be granted. I am ready to deposit 50% of the order.
What have you not done? Affidavit is not sworn.
Not sworn.
ಅದು ಮಾಡಬೇಕಲ್ಲ ಸರ್. How oversight ಅಂದ್ರೆ? The gross error. ಅವ್ರು accept ಮಾಡಬಾರ್ದಾಗಿತ್ತು ಆಫೀಸ್. Week's time granted.
Accept and ಮಾಡಿಲ್ಲ ಅವ್ರನ್ನ.
ಆಗುತ್ತೆ sometimes. Happens. So do it. Now rectify. Will grant stay. If there is any execution file, even before your rectification, you can move the court.
Yes, my lord. Call this matter next week, my lord.
Yeah, release next week.
Watch out.
Siddaramaiah, week's time granted. Do the needful. Keshav Prasad.
I appear for the appellant in there are 4 connected matters. The TCR is required. First one is the negligence and liability aspect.
What is the amount? Just deposit ಮಾಡಿದ್ದಾರೆ. What is the total amount?
First case is 2,60,800. Deposit is 54,400.
This is the totally 4 matters.
There are 4 matters, my lord. My lord, I have questioned the liability fastened on the insurance company, my lord. So TCR is required. Once TCR my lord, received, it may be taken up for disposal.
You question the liability.
Yes, my lord. There was no charge sheet against me, my lord. There are
All
2
right.
vehicles involved. Against other vehicle, my lord, a charge sheet is filed. My lord, without any reason, since my lord, the other vehicle has no insurance, 50% is fastened against me. Absolutely, there is no reason for that. So that is what, my lord, I have questioned before your lordship. So TCR may be called for, my lord, may be taken up for final disposal. I am ready for
All
that.
right, let the TCR come, we will hear the matter and dispose it. Huh? No, you heard what he said. You heard what he said. He's challenging the liability itself. He has deposited. What about the other person? Has he come on before the court? Okay, we'll have it next week. Avoid ideal. TCR kept below ideal, Mr. Prashant.
I am ready, madam.
TCR is kept below. You are ready to argue? You come ready with the main argument. We'll dispose it off instead of passing orders on that because he is challenging the liability. Understand? Artha aitha nimge? All right. At request of learned counsel, this matter next week. Admission ga karna na. Avoid TCR and it is all same matter.
All are same accident.
Huh?
Same accident.
Accident arises of the same.
Yes,
same
yes,
accident.
Yes, ma'am.
Then what is the need of avoid TCR in the? What is the need of avoid TCR in the first matter when others are already there?
I don't know why it was mentioned. Common judgment is passed.
Release next week. Palakshaya. Jagdisha. ಯಾರಿಗೆ ನೀವು ಬರ್ತಾ ಇದ್ದಾರಾ ಐಎ ಏನು ಹಿಯರಿಂಗ್ ಐಎಲ್ ಏನು ಪಾಸ್ ಓವರ್ what is the pass over required for? Oh, this is that series of matters. How many matters? 1, 2, 3, 4, 5 matters. Then a KSRTC bus. All right, Burley. All of you are ready. Kaje.
I am appearing for the respondent, my lord.
All right. Claimant.
My lord, one submission, my lord. ಇದರಲ್ಲಿ 1813 ದಿನ ಡಿಲೇ ಇದೆ. ನಾನು ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕ್ತೀನಿ ಸ್ವಾಮಿ, ನನಗೆ ಸ್ವಲ್ಪ ಟೈಮ್ ಕೊಡ್ಬೇಕು ಮೈ ಲಾರ್ಡ್.
That counsel seeks accommodation to file objections. Same is granted. Release this matter after 2 weeks.
Please, my lord, oblige.
Cholamandalam. Learned counsel B. Pradeep, who is present before the court, accepts notice on behalf of respondent number 2. Heard. Orders on IA1. IA1 allowed 175 days in filing appeal condoned. Your claimant. Huh? However, on claimant being successful shall not be entitled to interest for delayed period. This for admission. IA1 is dismissed as not pressed. Since appeal is in time, R14. IA1 for CD not pressed by counsel.
You only formally filed there is an PA. At the time of scrutiny, the office has moved.
Who are you? Who is the appellant?
Is the passive owner of the vehicle.
Pending vehicle. You're seeking stay. You don't want stay.
I want stay. I want stay.
But I'm not seeking stay. If you don't want stay, we'll
There is an application.
file for stay. Ah,
What is the liability? The tribunal has
liability is fastened on whom?
the owner.
So now you want to shift it to the insurer.
FIO has purchased the vehicle. India.
No insurance. No insurance.
There is no insurance. There is no insurance. 29/11/2011 itself the vehicle was sold.
Huh?
29/11/2011. 29/11/2011.
29/11.
2011. The vehicle, offending vehicle was sold. Who respondent number 4 is
29/11/2011. You sold. You means you are, who are you? What is your name?
Who respondent number 4.
Your Karibasappa. So Karibasappa is respondent number 2.
Respondent number 2 reported
Tribunal. So you sold it on 29/11. Accident took place on 3/10/2014. So you sold it to whom?
The respondent number 5 here is purchaser.
Shiva. Alias Shivana, son of Ramachandra. Idarala, he's R4.
Respondent number 1, respondent number 3 Ravi was the rider along with the
You sold it to R4. Who was the
R5 Ravi is Shiva.
the R5 now? He was R4 in the tribunal.
Yes. Total 7 lakhs is awarded. Because very.
So if you have sold it, the RC has not got changed.
The delivery note was issued to me. To respondent number 4 is an agency. To him, the respondent number 5 has purchased the vehicle. And he uses the vehicle for more than 3 years in the public road.
You did not lead evidence.
Yes, we have evidence.
So what has the tribunal done?
The tribunal done, my lord, the delivery note has not
Been accepted.
Despite of the judgment which are pronounced by the same court produced in similar manner. The tribunal has come to conclusion there is some doubt is arise in the implication of the vehicle itself. Therefore, my lord, the respondent two get responsible for the entire.
You are Kumar. Barkoldrama, IU1 dismissed as not pressed since appeal is in time. Heard learned counsel for the appellant. Orders on IA number 2. Before that, madam, heard learned counsel for the appellant. Issue notice to respondents. Now orders on IA number 2 of 21. There shall be stay of operation of judgment and award dated 27/2/2020 in MVC 1519 of 15. And also execution petition number 177 of 2020. Huh? All right, madam, execution order that in MVC 1519 of 2020, subject to the condition that the appellant herein deposits 50% of the award amount.
Because we are seriously disputed.
Normally, we are awarding 50% to everyone. So same also holds good for 50% to the 50% within a period of 4 weeks from today before the MACT, before the executing court and that. Consequently, there shall be stay of execution proceedings in execution petition number 177 of 2020.
Go with it.
Next. Release of amount. ನೀವು ಯಾಕೆ ಚೇಂಜ್ ಮಾಡ್ಕೊಂಡ್ರಿ? There any understanding between both of you that you will appear for appellant and or first time you are appearing? Normally this side is for appellant, this side is for respondent. Yes, sir. Yes, filed. Yes. What who's R2? Liability is on? Who's Naveen Tao? You are appearing for whom? Who are you? Claimant? Only one person? Claimant is only one. All right, you pay and recover. How it is concerned to him?
The hospitalization expenses.
Every.
Appear before the court and say let him detect.
Huh?
But trial court has made an order of pay and recovery. I have deposited 50% as per the order of this honorable court.
You are challenging liability.
Every.
Even if you challenge liability, if it is shifted to the owner of the offending vehicle, it is between you both. You still have to pay and recover it from him. Accordingly, heard learned counsel for the appellant and learned counsel Naveen Tao. Huh?
Minor was driving the vehicle.
Sir, we are not hearing the matter on merits, sir. Pushpendraya. Whether you have any objection for release of amount. Minor was driving the vehicle and you are attributing now negligence on him. He was a rider.
He is a third party. Minor was driving the vehicle in this case, my lord.
All right. He is not the minor.
Not the minor.
ಓದಿಲ್ಲ ನೀವು. Yes, 34 years. He's 34 years, sir. Sir, the offending vehicle is a minor. How does it affect him, sir? Does not matter. You take your own sweet time. He needs the money. It is between you and the offending vehicle whom you have insured. Between you both, you fight it out. Why he should suffer? He's 34 years old, traveling with his wife. Third learned counsel for the appellant and learned counsel for the respondent number 1 claimant. This application is filed for release of amount in deposit made by the insurer, who's the appellant herein. Said amount has been deposited before the MACT. Admittedly, 50% of the amount has been deposited wide as per. ಎಷ್ಟು 60 ಮಾಡಿದಾರಾ? 60% of the amount has been deposited by the appellant insurer. ಎಲ್ಲಿ ಹೇಳಿದಾರ ನಿಮ್ಮ ಅಫಿಡವಿಟ್ ಅಲ್ಲಿ? ಆರ್ಡರ್ ಶೀಟ್ ಅಲ್ಲಿ ಇದೆಯಾ ನೋಡಿ ಮಾ. 60 ಎಲ್ಲಿ? ಬಿಫೋರ್ ವಿಚ್ ಕೋರ್ಟ್? Before tribunal. There is no dispute with regard to same. Full stop. The respondent number 1, who is the claimant, has filed the present application seeking withdrawal of the amount. Full stop. Having perused the affidavit annexed to the application, I do not find any legal impediment in allowing the application and permitting the respondent number one claimant to withdraw the amount deposited by the appellant insurer. We find bank details. All right. Therefore, IA number one is allowed. Claimant, respondent number one claimant is entitled for release of 60% of the amount in deposit made before the tribunal. Full stop. Is the contention of learned counsel for the appellant that the rider of the offending vehicle was a minor as on date of occurrence of the accident, hence disputes the liability. However, that does not alter the compensation that would be awarded to the respondent number one claimant. Therefore, registry of the tribunal is directed to release entire 60% of the amount in deposit in favor of the respondent number one claimant upon proper verification. Full stop. If the respondent number one claimant produces the necessary bank details, IFC code, and all other particulars, the amount shall be transmitted to the account upon proper verification. R2 ಏನು await notice of R2. ಅದು ಸ್ಟಾರ್ಟಿಂಗ್ ಎಲ್ಲ ಹಾಕ್ಬೇಕಮ್ಮ, await notice of R2. Then orders on IA. IA dismissed as not pressed since appeal is in time. Issue notice. Issue notice on IA and the main. Any other cases filed? Registry to list MFA 2883 of 2022 along with this appeal. Padi. Stay agidi adralli. What is the order passed?
Short time.
Granted, allowed. Stay granted. So same will come to the benefit of this common order. No, but different parties. Then we have to pass an order here. Third learned counsel for the appellant. Issue notice to respondents. ಅದರಲ್ಲಿ certified copy ಕೊಟ್ಟಿದ್ದೀರಾ? Orders on IA1. In view of the fact that in the connected appeal MFA 2883, the certified copy of the appeal order is furnished. The same is dispensed with in this case. Accordingly, IA1 is allowed. Stop. Orders on IA2. There shall be stay of operation of judgment and award dated 9/12/21 in MBC 1153 of 17, passed by Court of Senior Civil Judge and Additional MACT at Sira, subject to the condition that the appellant deposits 50% of the award amount. Delhi, before the tribunal within a period of 4 weeks from today.
My lords, I appear for appellant, my lords. It's an appeal by the insurance company. We have questioned the liability, my lords. In fact, the insurance company had led in evidence regarding non-possessing of the permit at the time of alleged accident. But still that is not being considered, my lord. And in a connected matter, kindly my name may be shown, my lord. I'll file wakalat. And earlier, both the matters were filed by Mr. Rajgopalan. As he is no more, it came to be entrusted to two different advocates by the insurance company, my lords. I will take notice to the owner in the connected matter, my lords.
number 1 to 3. Now, the 67.1 is filed by whom?
It is also, there are two connected claim petitions that were filed, my lords, arising out of the same accident.
Madam Geeta, the
Yes, my
first
lords.
matter is filed by you. You're for the insurer, KSRTC, na?
Yeah, no. It is New India Assurance Company.
Okay, by the insurance company. The second
Yes,
matter
my
is
lord.
filed by?
Second is also from the insurance company. As Mr. Rajgopal passed away, they reassigned the matters to advocates. Then they might have missed out and assigned it to two different advocates, my lords.
So second is also filed by your insurer?
Yes, my lords.
Your name is to be shown?
Yes, my lords. I'll take notice to the owner in the second matter, my lords.
Lama,
Owner and the...
please don't confuse the court now. My question is, the first matter is filed by New India Assurance.
Yes, my
You are
lords.
representing. Second
Yes.
matter is filed by Venkatesh Kamath. Is that also by New India Assurance?
Yes, my lords.
Then why don't you will continue in
Yes,
instead of Venkatesh?
yes, my lords.
But why? How you will take notice? You will appear on instead of Venkatesh Kamath.
No. I said I take notice to the respondent numbers 1 and 2. That's what I was saying, my lords.
So Venkatesh Kamath is available?
No, it seems that he has given no objection to the insurance company. I'll collect it and file it, my lords.
All right. Direct counsel for the appellant insurer, Srimati Geeta Raj, submits that the second appeal in MFA 2561 is also filed by the insurance company, aggrieved by the very same impugned judgment and award. First. Second one. But the appeal has been preferred by learned counsel Venkatesh Kamath. She submits that the said learned counsel has given NOC Wakalat in her favor. Hence, registry to show the name of Srimati Geeta Raj as well in this appeal for as learned counsel appearing for the appellant. ನೀವು ವಕಾಲತ್ ಹಾಕ್ಬೇಕು ಅದಾದ್ಮೇಲೆ ಅವ್ರ ಹೆಸರು ಡಿಲೀಟ್ ಮಾಡೋದು.
ಆಯ್ತು ಹಾಕ್ತೀನಿ ಸ್ವಾಮಿ.
ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್ 1 and 2 ಯಾರು ಇದರಲ್ಲಿ ಸೆಕೆಂಡ್ ಮ್ಯಾಟರ್ ಅಲ್ಲಿ
ಕ್ಲೈಮೆಂಟ್ ಮತ್ತೆ ಓನರ್ ಸ್ವಾಮಿ.
ಇವರು ಇದಾರಲ್ಲ ಕ್ಲೈಮ್ ಯುವರ್ ಫಸ್ಟ್ ಮ್ಯಾಟರ್.
ಇಲ್ಲ ಸ್ವಾಮಿ, ಅಲ್ಲ ಫಸ್ಟ್ ಮ್ಯಾಟರ್ ಅಲ್ಲ.
ಮೇಡಮ್, ವಾಟ್ ಇಸ್ ಯುವರ್ ಪಾರ್ಟಿಸ್ ನೇಮ್?
My lords, I have a submission, my lords. There were two claim petitions filed arising out of the same accident, my lords, in two different
First
MBC
is
cases.
And second is
Yes,
injury.
and injury, yes, my lords. So I would take notice to the claimant and the owner in the second matter.
Week's time granted to take out notice for respondents 1 and 2. If needful is done, registry to issue notice to respondents 1 and 2.
Yes,
Correct?
yes, my lords. Yes, my lords.
Second matter.
Much obliged, man.
Yes, in the first matter, lady, what is this production of document?
I have, because the tribunal, while assigning findings on liability, though I had examined RTO, had said I have not produced document to show that on the date of accident there was no
So
permit.
you're producing
So I'm
those
producing that document.
So
That's
we'll
all.
consider that is the main.
Yes, my lords.
What is this notice to R4?
R4 is the again
HS?
owner, my lord. I'll take notice, my lords.
ಇಲ್ಲ ಅವರ ಹೆಲ್ತ್ ಸಫಿಷಿಯಂಟ್ ಆಗಿದೆ, not required.
Yes, my lords. The paid recovery order
served ಅಂತ ಹೇಳಬೇಕು. Registry to show respondent number 4 Afsar Khan as served instead of showing as held sufficient. Held sufficient. Okay, but my order, what is that? In view of the fact that notice to respondent number 4 is held sufficient, the same is deemed as served. Same is deemed as served to stop registry to show respondent number 4 as served in the cost list. Yes.
Much obliged, madam. Grateful, my lords.
Latur. Keshav Prasad.
I appear for the respondents case.
Workman's compensation.
Oh.
Delhi, Latur. Suresh Latur. There's no representation on behalf of appellant. Learned counsel for respondent 2 is present. Released next week. Siddaramaiah.
I am appearing for the respondent number 2, my lord.
R1 and R4 they are one and the same. R1 was deleted before the MACT. I have also filed a memo to delete, but phosphate has deleted. You permitted to delete.
4864. So R1 is Panchakshari. She has been deleted before the tribunal itself. All right. Ilena deleting the name of R1 from first title of the appeal. Order agila adralli. Order agila adralli. Order agila alri.
The records money there, I am ready.
You are also ready.
I am appearing for the respondent number 2, my lord.
Who are you?
Purti Yagade. My lord, I am.
Who are you appearing?
I engaged a claimant, my lord, to engage the erecting electric line, my lord. While he was doing the work, appellant.
Sir, who are you? And ಕೇಳಿದ್ರೆ ನೀವು merits ಮೇಲೆ argument ಮಾಡಿ.
No, my lord, I am engaging the claimant, my lord, to do work, my lord. I am not owner of the. I am not owner of the. No, employer, my lord.
Employer.
Employer, my lord.
Your employer.
Employer.
In MFA 4864, learned counsel for the appellant has filed a memo seeking for deletion of respondent number 1 from the cause title, as respondent number 1 was deleted before the tribunal itself by order dated 6/7/2017. That memo is accepted. Learned counsel for the appellant is permitted to delete respondent number 1 from the array of parties before this court in this appeal. From array of parties in this appeal before this court. Registry Kebbilo Bandide. Are you ready? Siddaramaiah, na? At request of who are you? How are you? What is he? Who is he? Offending vehicle owner, Henry. Really, are you appearing for the first time in MEC MFA matter? Whether you say whether he is owner, insurer, offending vehicle, third party. Learned counsel for the owner or owner of the offending vehicle seeks time. Sri Siddaramaiah seeks time. Released next week. You have to come to the point quickly, sir. Let us save the time. Venkatesh.
I am appearing for the appellant, my lord. My lord, I have deposited as per the orders of disclosure.
Carry out the correction, Mr. Karigowda. Carry out. Yes, Venkatesh.
25/3 ನಾನು ಹೈಕೋರ್ಟ್ ಗೆ ಡೆಪಾಸಿಟ್ ಮಾಡಿದ್ದೀನಿ ಸ್ವಾಮಿ ಆಸ್ ಪರ್ ದ ಆರ್ಡರ್ಸ್.
You are insurer?
ಹೌದು ಸ್ವಾಮಿ, ಇನ್ಶೂರರ್ ಅಪೀಲ್ my lord.
What about the postal shara? Yenagide madu? R1 and R2 served antide.
Oh, sorry.
Confirm. Now you are seeking, what are you seeking here?
My lord, is it 72, my lord?
72.
Oh, correct. Nanu appeal. Yes, my lord. Insurance appeal, my
Lakshmi
lord.
Narsimaya.
How so, me?
Tala mele light hakonbitte adu, it is showing like Sai Baba's light coming right from behind.
Illi belakku kaanalla, my lord.
Light should be focused on your face, not on your head.
Sorry, my lord. I will correct.
The illumination of light from behind.
How so? Correct, my lord.
All right. So now what you are challenging? What are you challenging here?
Idu future prospects kottidare. So injury claim, amputation case, interest to 9% kottidare.
Adella modify agutte. Suppose I agree with you.
Yes,
if I agree with you,
yes, ma'am.
Then it will be modified. The claimant would be required.
Records next week. I will assist the court in
you do one thing. Though the notice is served, you take out once again notice on the counsel who had appeared for them before the tribunal.
Sorry, so much.
This Berkoli, Third Learned Counsel Sri Lakshmi Narsimaya on behalf of appellant, despite notice having been served on respondents 1 and 2 who are claimants, there is no representation. In view of the fact that this appeal is preferred by the insurer, challenging the quantum and the interest portion being exorbitant, I deem it appropriate to direct the appellant to serve copy of the notice of this appeal to the learned counsel who had appeared for the respondent claimants before the tribunal.
Sorry, sir.
Trial court records beka?
Oh, bekagutte, my lord. Bekagutte, dayaviಟ್ಟು ತರಿಸಿ ಸ್ವಾಮಿ.
Registry to secure TCR. Prakash MH. KP Bhuvan. What are you challenging? Liability? Illa. No insurance. So you are challenging quantum.
Specific ground of contributing negligence on the part of the deceased was taken.
So that is held against you. So no contributory negligence in target. Who's mentally retarded? So was she driving or walking?
And this truck was following the car and she saw the police of this.
How old was she?
51 years. 14,000 even the assets considering the legal services 12,000.
Just again. So on what basis 14 is taken? Para 19. So what is that judgment in Yashoda versus Acharya? Did you take up this plea that she was mentally not stable?
What is the document? B13 notarized copy of the issued by the health department which disclosed that the disease was an retarded process. But that is not a ground to reject it like it. Most of the records of notarized copies of the other cards are compared. So it has, the has observed it. Still it has proceeded to what compensation. Where
Third learned counsel for the appellant to the owner of the offending vehicle. issue notice to respondents. Oh, idara now. Issue notice better. Issue notice better. Orders on IA1. There shall be stay of operation of judgment and award dated 14/12/2021 in MVC 936 of 2019, passed by Additional Judge, Court of Small Causes and MACT Bengaluru City, SCCH4, subject to the condition that the appellant herein deposits 50% of the award amount within a period of 4 weeks. Why? We'll consider. No, if it is modified, it will be modified. The standard procedure is 50% within a period of 4 weeks from today. No, that is also standard. To violate standard procedure, you have to show 75% ಮಾಡಬೇಕು ನಿಮಗೆ. Who was not insured the vehicle, 75% ಮಾಡಬೇಕು. I don't think a vehicle is released in other European countries without being insured. We cannot even take it out on the road. Yes. So ನೀವು ಮಾಡಿಲ್ಲ. You have taken the liability on you. Don't worry, I am going to pay. I am loaded with money. Is what your stand is. Yes, sir. Before this court, before the tribunal, Madi, before the tribunal. Passover ಯಾವುದು ಇತ್ತಲ್ಲ? How many Passover?
My lord, serial number is 29, my lord.
1 minute.
Serial
1
number
minute.
29.
29.
Yes, my lord.
ಯಾವ್ದಮ್ಮ Passover ಆಗಿರೋದು? 29. Yes, 29 is Raghu and Raghu. Yes, correct. 29.
Yes, my lord.
Padi.
My lord, it is a very simple matter, my lord.
What about 1 minute, sir? Rangegowda, Allah? Pradeep and madam, your other side is here? All are here? What about other? Anybody is required? Yaro adu? Palakshay. So if you have the number, just call. After this matter, we'll take up yours. All right. Yes, Mr. Raghu Vijay Kumar.
Please, my lord. My lord, this is a very simple matter, my lord. There is no dispute with regard to the liability and quantum of negligence. Only the point is, my lord, to be considered by this honorable court is only with regard to the quantum of compensation, so what the petitioners are entitled to.
So liability is also not in dispute?
Not in dispute, and there is no the negligence also. So this honorable court need not consider all those aspects. Simply your worship can say it is admitted. The negligence is admitted, not in dispute, and also.
So what are you now? What's your point of argument?
My lord, the accident is of the year 2016, my lord. 2016.
Yes.
My lord, the notional income, my lord, 9,500 per month. But the tribunal has taken 7,500 per month. The decision is paragraph, my lord, 19, my lord. 19, paragraph 19. In the next page, there is a discussion.
So 9,500.
9,500 to be taken. And my lord,
Yes.
since the decision is about 34 years, my lord, 40% of the future prospectus to be added.
That is also correct.
Yes, my lord.
That's
Then, my lord, the proper multiplier for the age group between 31 to 35, my lord, is 16 multiplier. But the tribunal has taken, my lord, only 7,500 rupees. That should be corrected.
So multiplier also correct.
Multiplier also correct. Future prospectus is also correct. Only the difference between 7,500 to 9,500.
So death case only. What about consortium?
Consortium, my lord, there are tribunal has awarded, my lord, 70,000 rupees. My lord, there are three claimants, my lord.
2 lakhs, 40 into 5. 2 lakhs.
Yes, my lord.
ಅಷ್ಟೇ ಅಲ್ಲ.
That's all. That's all. Very simple, my lord.
ಬರ್ಕೊಳ್ಳಿ. That's all. You want to say anything?
9,500 into 40%, 16 multiplier.
Yes.
And my lord, regarding rate of interest, my lord, 8% to be awarded. 8% award agide, 6% to be awarded.
8% award
agide. That is on higher side, my lord, 6% to be awarded.
ನೀವು ಅಪೀಲ್ ಎಲ್ಲ ಹಾಕಿದ್ರೆ
ಬೇಕಾಗಿಲ್ಲ. Your lordship can pass that order, my lord. Just and reasonable compensation.
Yes, you said something. ಯಾವುದು?
6% ಮಾಡ್ತಾರೆ. harassment compensation ಅದು 6% ಮಾಡ್ತಾರೆ.
6%. May I make one submission, my lord? May I make one submission? I am sorry to make this submission. My lord, regarding negligence and liability, my lord, you ask me kindly with the simple words. It can be said and when there is no dispute, my lord, there need not be too much of discussion about that. I am sorry to make this submission. So that it will avoid the court time also.
It's preferred by the claimants, aggrieved by the judgment and award passed by the Water Action Claims Tribunal, Court of Small Causes, Bengaluru, in MVC 8403 of 2016, dated 10th April 2018. Stop. This appeal is premised on the ground of inadequacy of compensation. Stop. Brief fact of the case. On 27/9/2016 at 7:15 p.m., when deceased Tinganna was riding his bike carrying registration number KA04 EY 1486 from Kunigal side towards Tumkur, and while proceeding on the left side of the road, at that time a lorry bearing registration number KA07 6594, driven by its driver in high speed in a rash and negligent manner, dashed against the bike of deceased from behind, due to which deceased sustained fatal injuries and died on the spot. Immediately thereafter, the body was shifted to Kunigal CHC, wherein the doctors conducted postmortem and he was declared as dead. It is stated that claimant was hale and healthy and aged about 34 years, doing plumbing, centering and agriculture work, earning more than 600 per day. Full stop. Due to the untimely death of deceased, who was the sole breadwinner of the family, the claimants herein, who are none other than the wife, minor children, and parents of the deceased, have lost their beloved one, and also have lost the only source of income for maintenance and sustenance of their family. So accordingly, they filed claim petition seeking compensation. Stop. On service of notice, respondents appear before the court. And respondent number 1, owner of the vehicle, admitted the ownership, denied the negligence on his behalf, whereas the respondent number 2, insurer, admitted the issuance of insurance policy to respondent number 1, but denied its liability initially and sought for dismissal of the claim petition. After the framing of relevant issues for consideration, in order to substantiate the case, the appellant claimant examined PW1 and got marked exhibits PW1 and PW2 got marked exhibits P1 to P13. whereas respondents did not lead any evidence on their behalf and neither produced any documents. On the basis of material evidence, both oral and documentary, tribunal passed an award granting compensation to an extent of 15,82,000 with interest at 8% from the date of petition. Full stop. Now the point for consideration before this court is whether the claimant is entitled to enhancement of compensation. Some of the admitted facts and undisputed facts are the ownership of the vehicle of offending vehicle of respondent number 1, the respondent number 2 insurer admitting the issuance of insurance policy and the same being in operation as on date of occurrence of the accident. In view of the same, this court need not dwell upon the occurrence of the accident, negligence having been committed by the driver of the offending vehicle, lorry, MV lorry, and the police records, namely exhibits P1 to P8, wherein the jurisdictional police has lodged a criminal case and laid a charge sheet against the driver of the offending vehicle. Since all these aspects are not disputed, I do not find any reason to dwell upon these aspects as they are admitted and undisputed. Full stop. Coming to the aspect of age, avocation, and income, the tribunal has assessed the income at 7,500 rupees per month. Admittedly, there is no proof of income produced by the claimants. Hence, the tribunal has taken the income as 7,500 per month. Full stop. In a case on hand where there is no proof of income produced by the claimant, this court is left with no other alternative but to do guesswork. And for doing the same, standard procedure has been adopted by the Legal Services Authority by prescribing a notional income chart, which prescribes 9,500 for the year 2016. Full stop. Accordingly, 9,500 is required to be taken as income as against 7,500 adopted by the tribunal. The age of the claimant, the deceased, and the multiplier adopted by the tribunal is also not in dispute. Hence, the same is not going to be dwelled upon by this court. The only point for consideration would be the income which should be taken as 9,500 per month. Full stop. Therefore, the loss of dependency adopted by the tribunal would have to be modified in view of the income being enhanced by this court to 9,500. Accordingly, 9,500 plus 40%, calculate madre entry, 40% as future prospects.
3,800. 3,800.
Just take the total 9,500 plus 40 would be
13,300.
300. Just dependence idro deduction esto. Since there are 4 dependents, 5 are. There are 5 dependents.
1/4 to be deducted, my lord. 1/4 to be deducted.
5 dependents. In view of the judgment of Sarla Verma versus Delhi Transport Corporation, 1/4 requires to be deducted towards personal and living expenses, which is rightly adopted by the tribunal. Therefore, 13,300 divided by 1/4.
9,925. 9,925.
Would be 9,925.
For 1 year, my lord, 1,19,700.
One nimsha. Your calculation, my calculation should not. Yes, sir. 9,500 percent will be 13,300 divided by 4. 9975 already.
Yes, my lord. 9975.
Now 25 and 9975 would be the income available towards the family for its sustenance and welfare. Therefore, 9,975 into
12 for 1 year.
Into 16, huh?
Yes, my lord. 19,15,200.
19,15,200
plus
would
2,000
be,
towards the loss of consortium.
Would be the loss of dependence. Full stop. Towards loss of estate, the tribunal is awarded 15,000, and towards loss of funeral expenses and transportation of the dead body, 15,000, which does not call for interference. Towards loss of consortium, the tribunal is awarded 40,000, whereas Learned Counsel for the appellant claimant contends that the tribunal ought to have awarded 40,000 per head as contemplated by, as held by the Honorable Apex Court in its constitutional bench judgment of Pranay Sethi, National Insurance Company versus Pranay Sethi, subsequently followed by judgment of Sachinder Kaur. Therefore, 40,000 into 5. Therefore, in the present case on hand, there being 5 dependents, 40,000 into 5 would be 2 lakhs. 2 lakhs is awarded as against 40,000 towards loss of consortium.
The total amount, 21 lakh 45,200. 21 lakh 45,200 is the total compensation.
Plus 2 lakhs plus 30,000. 2 lakh is to
21 lakh 45,200.
Correct. Therefore, in all, the appellant claimants would be entitled to 21 lakhs 45,200 as against 15 lakhs 82,000 awarded by the tribunal. Full stop.
The enhancement, my lord, 5 lakhs,
yes.
5,63,000.
5 lakhs.
You asked me to say, yes, the enhancement is not necessary. This amount carry interest at 6% per annum. 21 lakh 45,000.
Accordingly, I pass the following order. Appeal is partly allowed. Judgment and award passed by the so and so is modified. Claimant is entitled to total compensation of 21 lakhs 45,200 as against 15 lakh 82,000. To stop. Next point. Enhanced compensation.
Not enhanced compensation, entire compensation.
Enhanced compensation.
8%.
6% from the date of petition. Date of petition. The enhanced compensation shall be paid and bar deposited by the respondent insurer within a period of 6 weeks from the date of receipt of copy of this order.
But there is no interest on the delayed period.
Yes, the delay.
493 days. 493 days.
There shall be no claimant shall not be, appellant claimant shall not be entitled for interest during the delayed period of 495 days.
93 days.
R1. Starting a lot of memo notice. Madam, notice to R1 dispense with as no liability is fastened. Yes, sir. Thank you.
Much obliged. Much obliged.
ನೀವು appeal ಹಾಕಿದ್ರೆ Vijay Kumar could have reduced that interest portion.
Even otherwise not, even the division bench not passes interest on the entire compensation. Court has got power, because
that's correct.
Law prescribes only 6%.
What the court, Honorable Apex Court,
when the compensation is just and reasonable according to me, then my lord, we need not file interest. We not file the appeal. only for the interest, my lord, it is not fair on the part of the insurance company to file the appeal and get it reduced. Instead, request the court to consider in an equitable way, so that court will consider it and pass interest on the entire compensation.
Henry, what are the interest 6%? Because there is enhancement of compensation. We reduce the interest from 8% to 6%.
No, your my lord, your lordship say need not say that it is reduced to 8%. The entire compensation with interest at 6%. The enhancement of not the enhancement
compensation amount
carries interest at 6%.
What he's saying is what is awarded by the tribunal itself is wrong. 8% is wrong.
No, not necessary. It is not necessary.
All right. Next.
Much obliged.
$69, 59. Palakshaya has to come. Ashok Patil. So your Jagdish, Madam Bhushani is here. Palakshaya Anand. So Anand is not required. All right. What about Ashok Patil? So 1, 2, 3, 4, 5, 6, 5. 5 appeals. All were passengers, inmates in the bus. Rider of the rider and pillion rider. He appears for both. Pillion rider, your rider. So you are seeking for compensation enhancement. So that is yours is 59.3, 59.4 for enhancement. 0.5. 0.5 ಎಲ್ರಿ ಇದೆ. ಇರೋದೇ 0.3, 0.4, 0.5 ಬೇರೆ ತಗೊಂಬರ್. So both of you in 59.3.4 are claimants seeking enhancement. Ashok Patil appears for insurer. Palakshaya appears was of yours. Palakshaya appears for KSRTC, which is the offending vehicle. Patil Ray, you are the insurer of the vehicle which is involved, two-wheeler vehicle. So the tribunal has fastened the liability on.
My case only on KSRTC. In his case, on both KSRTC and motorcycle.
In his case. In one case, one court did not deal with the matter.
There is question by me. KSRTC as well as my submission would be.
Now you are appearing for the two-wheeler insurer. So in case I agree with you, what happens to Palakshaya? He has to pay 100%. Our ಬೇಕಲ್ಲ ಮತ್ತೆ. ಅದಕ್ಕೆ ನಾನು ಹೇಳಿದ್ದೆ ಅವ್ರು ಕರೀರಿ ಅಂತ. He's here in the campus. Final hearing is the matter. Varadaraj Ranganath, Keshav Prasad. Either 75 Vidira. Keshav Prasad is here. Basuraj. We'll take up this matter. You call him. In the meanwhile, I'll just finish the round. Karin.
Number 75.
What about 74 urgent? Keshav Prasad, are you ready?
Yes, yes, madam. I am ready, madam.
Yes, Basuraju. Really, name friend Pradeep idara. Yeah, what is this Keshav Prasad injury case?
Like case of injury, my lord, was an income tax payee. Tribunal granted, my lord, the future loss of income and loss of income during laid-up period. On two grounds, my lord, I have questioned. There was no loss of income, my lord, as per the as admitted by the cross-examination, and as well as, my lord, he has filed the income tax returns also to show that, my lord, there was no loss of income actually because of the injury suffered.
Yes.
That is, my lord, the main issue involved in the case.
But your friend is not here, sir. How to proceed in the matter?
Take on upon some other day, my lord.
We will see. We will wait for some more time. It's just 12:30 now. Because you are ready anyway. We will see. I will take up the other matter and come back to you.
Please, please, please.
Meanwhile, you can attend to your other work.
Please, much.
Rangegowda, ready? Ali, put it. No liability on R1. Admitted. So what is disputed?
Unreported negligence on the part of the appellant, 60% has been deducted. Only is not a billion rider. Is billion rider. As per police records and by evidence, my client petition filing as a billion rider. And the trial court may not come to the conclusion that he himself is the
rider. So the factually wrong. Factually wrong.
Therefore, 15% has been deducted without there being any evidence.
Where is that paragraph?
19.
Petitioner was riding the motorcycle without having valid driving license. Evidence for the other para 19 ali.
Clearly stated that page 7 and 8 of ನಿಜತ್ವ ವಾಹನಕ್ಕೆ ನಾನೇ ಮಾಲೀಕನಾಗಿದ್ದೆ. ನಾನು ಇಲ್ಲಿಯವರೆಗೆ ವಾಹನ ಚಲಾಯಿಸಲು ಪರವಾನಗಿ ಪತ್ರ ಪಡೆದುಕೊಂಡಿದ್ದು ಇರುವುದಿಲ್ಲ. ಅಪಘಾತದ ದಿನ ವಾಹನವನ್ನು ನಾನೇ ಅಜಾಗರೂಕತೆಯಿಂದ ಚಾಲನೆ ಮಾಡಿಕೊಂಡು ಹೋಗಿ ನನ್ನ ತಪ್ಪಿನಿಂದಲೇ ಬಿದ್ದು ಗಾಯ ಮಾಡಿಕೊಂಡಿರುತ್ತೀನಿ ಎಂದರೆ ಸರಿಯಲ್ಲ.
Is denied.
ನನ್ನ ಹೆಸರಿಗೆ ವಾಹನ ಚಾಲನಾ ಪರವಾನಗಿ ಪತ್ರ ಇಲ್ಲದೆ ಇರುವ ಕಾರಣ ನಾನೇ ಅಪಘಾತದ ದಿನ ಕುಮಾರ್ ಎನ್ನುವರು ದ್ವಿಚಕ್ರ ವಾಹನವನ್ನು ಚಲಾಯಿಸುತ್ತಿರುವುದು ಸಾಕ್ಷಿ ಸರಿಯಲ್ಲ.
So he is denied that he is the rider of the vehicle and he did not have a driving license. What is the first sentence in Kannada? So he is the owner. So the insurer is liable. Whether the rider of the vehicle was examined? No. No, there is no appeal filed by them. So we have to only go on the basis of contributory negligence. So where is it held? On perusal, it reveals defense evidence. Defense of R2 is that alleged date of accident, petitioner was riding motorcycle without valid driving license. Negligence. So the vehicle you are seeking insurance is from which vehicle? Which vehicle came and hit you? So it is you are not seeking against your own vehicle. So you are seeking against the offending vehicle. So which is that vehicle? Car. Car. The car. So that is permissible. Date of accident is 18.
Private is about 25 years. Working as a mason, earning 20,000 a month. Now only house value become 8,500 considered. According to the tax, 1,500.
Tribunal has taken how much?
8,500.
What if this is a case of injury? What is the disability?
Disability after has been assessed 35 to the upper limb, 12% to the lower one.
You are satisfied with that?
Only 10% have been taken, you cannot 1%. For body disability, we will not assess 12%. Period may not. If I go to 500, is it? I have done the conveyance for 15,000.
So tribunal is second 10%. Doctor says 12%. You have suffered fracture of right distal radius. One day fracture. Fracture of right distal radius and ulna. Ulna ಎಲ್ಲಿ ಬರುತ್ತೆ? Forehand. So only one fracture. So multiplier 18 is correct. Where has he said?
Advice to perform other operations for removal of interest from right radius.
What's pain and suffering? 40. Loss of amenities. How many days you are inpatient? 15 days. So 15,000 is correct. Medical expenses 1 lakh is actual. Future capacity earning, loss of future income changes. Loss of income during later period. On the because of 12,500. The 25,500 is given on the basis of three months. So this will be 12,500. $37,500. So loss of amenities. What is your mason? Allah? So that will become 25,000 instead of 20,000. Towards pain and suffering, 40,000 is correct. So only in increase will be in loss of future income by making it 12,500. The multiplication is correct 18. That's all. Future medical expenses where is the evidence, doctor? What is it's not considered. PW2 para 37 odi. Doctor has stated petitioner needs another operation for removal of implants of right radius. Discharge phenomena. Implants are removed and petitioner has what is exhibit P7? P7 ಕೊಡ್ರಿ. How can it be? ಆವಾಗಲೇ implant ಹಾಕಿರ್ತಾರೆ. How can it be removed? Discharges while he was admitted in the hospital. P7. What is the basis of the exhibit P7 taken by the tribunal at para 37? Medical expenses serial number 2. Huh? No, where is that exhibit? Which exhibit is that? P7 LLE there, removal. So P7 is what date? 25/9/2018. What is the date of accident? 18/8. Where is the removal in this? Late in situ ಅಂತ ಇದೆಯಲ್ರಿ. Where is the evidence of doctor regarding future medical expense? ಎಷ್ಟು ಅಂತ ಹೇಳಿಲ್ಲ. That's all. So only that aspect, and then future expenses will come into play. But negligence will go because he is not the rider. He's a plain rider. Where is that negligence part of it in the order? Where is that negligence attributed by the tribunal? Yeah. 19. So you have not prepared any appeal. This is an appeal preferred by the claimant. Challenging the judgment and award passed by the third additional judge and motor accidents claims tribunal Bengaluru CH-18 within brackets. In MVC 5101 of 2018, dated 13th August 2019. Full stop. This appeal is founded on the premise of inadequacy of compensation. Brief facts. Kurkuli, sir. On 18/8/2018, at about 11 a.m., when the claimant was proceeding as a pillion rider in a motorcycle bearing registration number KA42 R9676, ridden by its rider in a slow and cautious manner from Satanur towards Kanakpura. And when they reached near Satanuru Shanti Hotel, Kanakpura Taluk, Ramnagaram district, at that time, a driver of a car bearing registration number KA41Z 2204, driving the vehicle in a high speed, came in a rash and negligent manner and dashed against the motorcycle, due to which impact the claimant and the rider fell down and sustained serious injuries. Full stop. Immediately, the claimant was shifted to Government Hospital Kanakpura, and after obtaining first aid treatment, he was referred to St. Philomena's Hospital, Vivek Nagar, where he took treatment as an inpatient and underwent surgery. Pursuant to which he was advised further treatment and follow-up of the same. Full stop. It is stated that prior to the date of occurrence of accident, claimant was hale and healthy, aged about 25 years, and was working as a mason earning rupees 20,000 per month. Due to the occurrence of accident, claimant has expended rupees 2 lakhs towards medical expenses and other incidental expenses and has sustained serious grievous injuries in the accident due to the rash and negligent driving by the driver of the offending car. To stop. Due to the said accident and the injuries suffered therein, claimant is not in a position to do his work as he was doing prior to the date of accident, and that he has lost his earning capacity, thereby losing future income and ability to earn higher income. Hence, he filed a claim petition seeking compensation. On service of notice to respondents who are the owner and insurer of the offending vehicle, they filed their detailed statement of objections. Inter alia contending that the claimant was not a pillion rider in the motorcycle, whereas he was the rider of the motorcycle. However, the respondent number 1 admitted that he is the owner of the offending car involved in the accident, and that the respondent number 2 is the insurance company in which he had insured his vehicle, and he had a valid driving license, and the driver of the vehicle had a valid driving license as on date of occurrence of accident. He further pleaded that in case of liability, the same will have to be fastened on respondent number 2, as R1 would have to be indemnified by R2 in view of the subsistence of the policy. It was also pleaded that the accident occurred due to the rash and negligent riding of the rider of the motorcycle, the claimant, who did not have a valid driving license, and so also he was not wearing a helmet as on date of the accident. The respondents also denied the age, avocation, and income of the claimant. Apart from denying the exorbitant amount of compensation sought for by the claimants, accordingly, they sought for dismissal of the claim petition. Just above this para, in between, you have to add the respondent number 2 insurer also took up the plea that the driver of the offending car did not possess a valid and effective driving license as on date of accident, and that the owner of the offending vehicle has not complied with the mandatory provisions of section 134 bracket C and 158 bracket 6 of MV Act. However, respondent number 2 insurer admitted the issuance of policy and the same being in force, subject to the terms and conditions of the policy. It was further pleaded that the claim petition is bad for misjoinder and non-joinder of parties, as the owner and insurer of the motorcycle were not arrayed as respondents in the claim petition. Full stop. Next paragraph. On the basis of the pleadings, the tribunal framed relevant issues for consideration. Next paragraph. In order to substantiate the issues and to establish the case, claimant examined himself as PW1 and got marked exhibit P1 to P15 in support of his case. Claimant also got examined PW2, doctor as PW2, and got marked exhibit P16 and P17. On the other hand, respondent number 2 insurer examined MRT andre enri MRT manager examined its manager examined MRT andre
Medical record technician, my lord.
medical
Record technician.
should know, sir. At least I should know. Examined medical record technician as RW1 and got marked exhibit R1 to R3. Full stop. On the basis of material evidence, both oral and documentary, the tribunal awarded compensation of rupees 3,28,695 with interest at 8% per annum in favor of the claimants. Favor of the claimant, favor of the claimant. However, saddled 85% of compensation, 85%, so 15%, 15%. %, as contributory negligence as against the claimant herein, thereby awarding 85% of the compensation to be paid by respondent number 1 and 2. In view of the policy being enforced, respondent number 2 was directed to pay the compensation amount. Full stop. Being aggrieved by the meager amount of compensation awarded and imputing 15% contributory negligence as against the claimant, appellant bar claimant, the claimant is before this court challenging the said impugned order. Full stop. It is not in dispute. It is vehement contention of learned counsel for the appellant claimant that the tribunal has erred in awarding meager compensation and has not taken into consideration material documents, both oral, material evidence, both oral and documentary, and has erred in awarding less compensation to the claimant, thereby causing miscarriage of justice to the claimant. It is further contended by learned counsel that the tribunal has committed a serious error in attributing 15% contributory negligence as against the claimant herein by ignoring the fact that the claimant was not the rider of the motorcycle, whereas he was a pillion rider. The said aspect having been ignored is a serious error in law which requires to be interfered by this court. It further contends that the tribunal has not taken into consideration the avocation of claimant and has awarded a meager and has assessed meager amount as income, thereby committing an error in not adopting the notional income chart prescribed by the Legal Services Authority. It is further contended by learned counsel that the tribunal has erred in awarding meager compensation under other heads and incidental expenses, thereby committing an error and not awarding just and reasonable compensation. It is also contended that tribunal has erred in not awarding 9% interest and has awarded only 8%, which is on the lower side. On the basis of these submissions, he seeks to allow the appeal and consequently enhance the compensation awarded by the tribunal. Full stop. Per contra, learned counsel appearing on behalf of the respondent insurer vehemently contends that the judgment and award passed by the tribunal is in accordance to the material evidence, both oral and documentary, and the same does not call for any interference at the hands of this court. Learned counsel further contends that the claim petition itself is liable to be rejected on the ground of non-joinder and misjoinder of necessary and proper parties. He contends that the claimant has not impleaded the owner of the offending vehicle and its insurer, owner of the two-wheeler and the insurer who are necessary and proper parties in the case on hand. Full stop. Learned counsel further contends that the tribunal has rightly attributed negligence at 15% against the rider of the motorcycle, who was none other than the claimant himself. Accordingly, the contributory negligence is rightly attributed against the claimant who was the rider of the vehicle. Full stop. On the basis of these submissions, he seeks to dismiss the appeal, as the same is does not merit consideration, as the same does not merit consideration. Full stop. Having heard the learned counsel for appellant claimant and learned counsel for respondent insurer, point that would arise for consideration before this court is whether the tribunal is awarded meager compensation, calling for interference of this court to stop whether the claimant is entitled for enhancement of compensation. Full stop. Next paragraph. Having heard the submissions of learned counsels and having perused the entire material evidence, both oral and documentary, and on perusal of the original records and the impugned award, judgment and award, I am of the opinion that the tribunal has committed an error in awarding meager compensation. Thereby, point number 1 is answered in the affirmative in favor of the claimant, and point number 2 is answered in the affirmative, where the claimant would be entitled for marginal indulgence for enhancement of compensation for the reasons stated here in below. It is not in dispute that accident occurred on 18/8/2018 at 11 a.m. between the vehicle in which the claimant was a pillion rider, between the motorcycle in which the claimant was a pillion rider and the offending vehicle, namely the car, driven by the driver in a rash and negligent manner. In order to substantiate this aspect and prove the same, claimant has produced exhibit P1 to P5. These are the police records wherein the driver of the offending vehicle, namely the driver of the offending car, has been charged with criminal offense by filing an FIR, spot Panchanama, MBA report, and a charge sheet. Full stop. There is no dispute that a charge sheet has been laid against the driver of the offending car. For the offences punishable under section 279 and 338 of IPC. Full stop. There is no challenge made to the laying of charge sheet either by the driver of the offending car or by the respondents herein. Full stop. It is also not the case of the respondent insurer that the said initiation of criminal proceedings against the driver of the car is fictitious and concocted. So also no contra material has been placed before the tribunal or before this court to prove the same as invalid or not being genuine. Full stop. In the absence of such material before the court, and there being no challenge to the charge sheet being laid against the driver of the offending car, the negligence is rightly attributed against the driver of the offending car by the tribunal. The point that, as discussed earlier, would arise as to whether there is contributory negligence against the rider of the motorcycle, and whether the claimant herein was riding the motorcycle as claimed and alleged by the respondents before the tribunal. To establish the same, no material evidence has been placed by the respondent, and neither is it elicited in the cross-examination of PW1 or even their own witness. A suggestion, no doubt, was put to PW1. The same is denied that by PW1, who's the claimant, with regard to the suggestion that he was riding the motorcycle. Full stop. Have you satisfied the amount? It is also submitted across the bar by the learned counsel appearing representing the insurer that the entire amount has been satisfied by the insurer. 85% amount has been satisfied by the insurer. Admittedly, no appeal has been preferred by the respondent insurer or the owner of the offending vehicle. Full stop. The tribunal has come to the conclusion that 15% contributory negligence is attributable to the rider of the motorcycle, on the premise that the claimant was the rider of the motorcycle and he was responsible for negligent driving to the extent of 15%. However, the tribunal has misdirected itself and lost sight of the fact that the case of the claimant was that he was a pillion rider and the motorcycle was ridden by another person. This aspect of the matter ought to have been established by producing proper material, cogent material evidence before the court by the respondents. The same having not been done, merely by stating that the claimant was the rider of the motorcycle would not suffice to attribute negligence of 15% and to come to a conclusion that the claimant was the rider of the motorcycle. What is the idರಲ್ಲಿ ಏನಾರ ಇದೆಯಾ FIR and criminal records ಅಲ್ಲಿ? Hence, there being no material evidence with regard to proof of the claimant being the rider of the motorcycle and the accident is occurred due to the negligence of the rider of the motorcycle being the claimant, I'm afraid the same is hard for countenance and cannot be accepted. I'm in agreement with the learned counsel for the appellant claimant that the tribunal has committed an error in attributing 15% negligence as against the claimant. The same requires to be set aside. Accordingly, it is set aside. Now, coming to the aspect of avocation, age, avocation, and income of the claimant. No doubt the claimant has averred in the claim petition that he was working as a mason and earning 20,000 rupees per month. However, no material evidence has been placed before the court with regard to proof of the said income and his avocation. ಏನು ಕೊಟ್ಟಿಲ್ಲ. The tribunal has assessed the income of claimant to be ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ? 8,500, as no material documents have been placed by the claimants. Stop. However, it is seen, admittedly, the accident has occurred in the year 2018. The notional income chart prescribes 12,500 as income to be adopted for the year 2018. Full stop. In the absence of any material proof with regard to income, the tribunal and this court is left with no other option but to do guesswork. And the same guesswork will have to be done in a standard manner, for which the Legal Services Authority has prescribed a notional income chart prescribing income for relevant year of accident. In the present case on hand, accident having occurred in the year 2018, 12,500 would be the income to be adopted for the relevant year. Accordingly, income requires to be assessed at 12,500 as against 8,500 taken by the tribunal. Full stop. Next paragraph. Claimant is aged 25 years as on date of occurrence of accident. And the appropriate multiplier to be adopted in this case is 18, as per the judgment of the Honorable Apex Court in the case of Sarla Verma versus Delhi Transport Corporation, which is rightly been adopted by the tribunal. Hence, the same does not call for interference. Full stop. Next para. Claimant has also examined Dr. SPW2, who has clearly stated on oath that the claimant has sustained fracture of right distal radius and ulna, and that he has undergone operation in the form of closed reduction and external fixation and K within brackets K within inverted commas K wiring of fracture of right distal radius, and that he has suffered permanent disability to an extent of 35.82% to right upper limb and 12% disability to the whole body. Though PW2 is not a treated doctor, is not the doctor who treated the claimant. The disability certificate kottidara? Huh? Yes, on the basis of clinical analysis and assessment of the claimant, has arrived at a disability to an extent of 12% to the whole body. Even if they said 35.82% to the right upper limb is divided by 3, as contemplated under the central government notification, gazette notification for dividing the body of a person into 3 parts, upper, middle, and lower, the calculation would come at 11.94%. Whereas the tribunal has assessed the disability to an extent of 10%. I'm afraid this cannot be accepted for the simple reason that the tribunal is not an expert and it cannot put itself into the armchair of an expert to decide the disability of a claimant, while the doctor has opined in his assessment on clinical analysis. Accordingly, the disability has to be taken at 12% rather than 10% adopted by the tribunal. Therefore, the loss of income due to the disability to the claimant would be as follows: 12,500 into 12 into 18 into 12 by 100. Just type 12,500 into 12 into 18 to 12%. 3,24,000. 3,24,000. As against 1,83,600 awarded by the tribunal. Stop. Para. Towards pain and suffering, the tribunal is awarded 40,000 as compensation. I do not find any illegality or infirmity in the same, hence the same is retained. Towards loss of amenities, the tribunal is awarded 20,000. I find this to be on the lower side, and the same is enhanced to 25,000 as against 20,000. Towards nourishment, conveyance, and attendant charges, the tribunal is awarded 15,000. He was inpatient for, which is rightly adopted by the tribunal as the claimant was inpatient for 15 days. Full stop. The tribunal is awarded medical expenses at rupees 1,02,600, which is on the actual bills produced by the claimant at exhibits P9 to P11. P9 to P11. Full stop. The same does not call for interference. Towards loss of income during laid-up period and rest period, tribunal is awarded 25,500 for a period of 3 months being rest period. In view of this court enhancing the amount of income as stated earlier, the same would consequently get enhanced at rupees 37,500 at the rate of 12,500 into 3 as against 25,500. Full stop. It is vehemently next para contended by learned counsel for the claimant that the tribunal has failed to consider the future medical expenses and has erred in not awarding any amount under this head. No doubt, no material evidence has been placed by the claimant. However, the doctor PW2 has stated on oath that future medical expenses would have to be incurred for removal of implants. The tribunal has not awarded any compensation under this head by holding that the implants have already been removed as per Exhibit P7. On careful perusal of Exhibit P7, which is a discharge summary, it is seen that no implants have been removed and that is only a discharge summary. It's not possible that the claimant at the time of discharge from the hospital has got his implants removed and nothing is forthcoming in the said Exhibit P7. Therefore, when the claimant has undergone fracture and implants have been made, which are in situ, SITU, the same would require one more surgery and removal of the implants. Accordingly, I deem it appropriate to award 25,000 as future medical expenses towards future medical expenses. Full stop. In view of the discussions made above, I'm not in agreement with the judgment and award passed by the tribunal with regard to attributing 15% contributory negligence as against the rider, as against the claimant who was a pillion rider, and no contra material having been produced to prove the fact that the claimant was the rider of vehicle and contributed to the occurrence of accident. Same requires to be set aside, and accordingly it is set aside. Full stop. The claimant would be entitled for enhancement of compensation as mentioned in the table below. Accordingly, I pass the following order. Appeal is partly allowed. Judgment and award dated so and so, passed by so and so in MPC so and so is modified. Claimant is entitled to a total compensation of so and so as against 3,86,700 awarded by the tribunal. Full stop. Claimant shall be entitled to enhanced compensation at 6%, which shall be paid within a period of 6 weeks from the date of receipt of copy of this order, which shall be deposited before the MACT. Full stop. The entire compensation is the entire liability is fixed on the respondent number 2, respondent number 1 and 2 na. In pay and recovery involved. Respondent number 1 and 2. The owner of the offending vehicle and the insurer. The insurer, having insured the vehicle and the policy being in subsistence, is liable to pay the compensation. Full stop. The differential amount of compensation. Right, enhanced compensation. Yes, what else? Records bandide. The registry to return the trial court records forthwith. Any delay? Baswaraju Bandra. You have made all of them wait. Palakshay, you are appearing for KSRTC. Now, Mr. Patil appears for the insurer of the two-wheeler.
Where the liability is fixed at
50. Please challenge that.
He has challenged his apportionment to the extent of 50%.
Correct. He says that should be on you. Because in
50% must be on the other side.
you have also filed 2 cases.
Yes, I have filed in respect of an accident dated 3/5/2016.
So your case is the entire liability should be on.
Accident was taken place due to the negligent riding of the bike by its rider, due to which the rider as well as the PM rider met with the other end of the line. And with those circumstances, once the matter has been before this honorable court on an earlier occasion, the matter was remitted back to the honorable tribunal to consider the matter. Later on, a fresh the tribunal has passed the judgment in afresh, and for the second round of litigation, we are before the court.
All right. So after this matter was remanded
Yes.
at your instance. So the first instance, what happened?
Same thing has been reaffirmed.
No, the first instance.
Also 50% in one
Case.
tribunal.
In one case.
And the another tribunal 10% liability must be done.
Only against the matter in which the rider was made a party, riders parents were parties that came up with direct report, and that was remanded saying that they have also contributed. Again, the question 5%. In that case, court and tribunal, it's only the case.
It's a death of both rider and pillion. All right. Now, rider and pillion, you are appearing for pillion.
I appear for the rider.
Rider.
He appears for the
All right. So both of you came up in High Court or which one? Rider.
rider, and I also came up in and the case of
Also came up in appeal. So in that,
I came up for enhancement at the time.
in the claim, in the tribunal's order, it was 50-50 or tribunal's order said 100%.
10% in one appeal. Unfortunately, my lord.
Sir, he did not come up in appeal at all. He did not come up in appeal.
On earlier occasion.
You came up in appeal. You came up in appeal only in her case.
No, we have questioned in both the matters.
Ivagalri. Munde kuda. No. Just understand because now it's time up. So, all right, let's assume that you challenge both. So in one case it was 10%, in the other case 50%. Remanded. Same order passed again. So now you are in again for the second time. All right, we'll hear you. 2:30. This court was ready at 12:30 to hear you. Sorry. Sorry, this must be relieved Andreno. You can request for relieving. Must be relieved Andre. When do you want it, madam? All of you should be there on the next date. Otherwise, this court will hear it. Tuesday, 5th. What, Mr. Patil? Wednesday is more auspicious. 5ನೇ ತಾರೀಕು ಮಾಡ್ರಿ. At request of all the learned counsels appearing for parties, release this matter on 5th April, 5/4. It is at the stage of interlocutory application. On the said date, the matter would be taken up for final disposal with consent. Yes.
I must be at home. I was intended to say that.
Early. No problem.
I'm sorry I was not able to.
ಇಲ್ಲ ಪರವಾಗಿಲ್ಲ.
That's okay.
34 and Krishna Swami. Okay. It's already adjourned. How I can change the date now? Trial court records has to come and it's adjourned next week. When it comes up next week, you can get it all both clubbed together, called together. On that day, we'll consider. We should be on time. We are on in the court. Yen madadu ivaga matter is urgent, file is gone. Can't do anything. Come on the next date, be on time. Next. Baswaraju. Who's Baswaraju? Keshav Prasad? That's the only one. There is no representation on behalf of respondent. No learned counsel for the appellant was present and ready in the matter. Hence, relist this matter next week. Which year is the MVC? MVC petition. 17. 17, relist next week. Yes, sir. Palaksha, get ready. Next.
I'm ready.
Yes. No, that's okay. Oh, no. Madam Bhushani is now still going to trial court or totally stopped going? Very active. I think you should be active like this. So also, learned friends.